You know, when you live in a planned community with an HOA, there are always rules. But what happens when the very people elected to enforce those rules decide to just ignore what the homeowners want? We're going to dive into a really fascinating story about a neighborhood power struggle that went all the way to a judge.
It all boils down to this one question. Can a small group of directors just find a loophole when a community-wide vote doesn't go their way? Let's find out. All right, so our story kicks off with something we can all relate to: money. We're at the Cottages at Coffee Pot, a little community of just 34 homes in beautiful Sedona, Arizona. And the HOA board there was facing a very familiar problem. Yeah, they were feeling the squeeze. The community needed more cash for everything, from keeping the common areas looking good to planning for bigger, more expensive improvements down the road. So this wasn't just some board on a power trip. They had a real, legitimate need to bring in more money to keep the neighborhood running. Now, to really get what happens next, you have to understand the two key documents that run pretty much every HOA.
Okay, think of the declaration as the community's constitution. It is the supreme law of the land. And in this neighborhood, you needed a massive 75% supermajority of all the homeowners to change a single word of it. Then you have the bylaws. These are more like the day-to-day local laws. The board can change these much more easily, but, and this is the absolute key to this entire story, the bylaws can never, ever contradict the declaration. So, with that in mind, let's look at the board's first move to solve their money problem. They decided to try and change the community's constitution.
So, in April of 2006, the board puts this big package of 4 major changes to a vote. First up, they try to make it easier to pass things in the future by lowering that huge 75% voting requirement. Then, they proposed a brand new 1% fee on every single home sale to raise money. They also wanted to add new rules about architectural changes, and this is a big one: get rid of proxy voting. This was their shot to really reshape how the community was run. And how did that go over with the homeowners? Well, they all failed. Completely. Not a single one of the amendments got enough votes to pass. The community had spoken, loud and clear.
And here's why. Because that very first proposal, the one to lower the voting requirement from 75%, failed. None of the other changes even stood a chance. They just couldn't get close to that supermajority they needed. So that's it, right? Case closed.
Well, not even close. The board had another idea. Since they couldn't change the Constitution, they figured, let's see what we can do with those local laws instead. You know, the bylaws. Now get this. The timing here is just wow. On April 27th, just 2 days before the vote was even finalized, the board went ahead and passed the architectural rule as a new bylaw. Then, on May 12th, only 2 weeks after their 1% fee proposal got shot down by the homeowners, the board just passed that exact same fee as another new bylaw.
Hold on a second. Isn't that literally the exact same thing the members had just voted against? Yes. Yes, it was. The board just implemented 2 of the key things the homeowners had just rejected simply by calling them bylaws instead of amendments. Well, you can bet somebody noticed. One homeowner saw exactly what the board was doing, saw it as a total end run around the whole democratic process, and decided, no way, not happening.
His name was Thomas Heekin, and he didn't just complain, he filed a formal legal petition. His argument was that the board had completely overstepped its authority and illegally bypassed the will of the members.
So here's how the legal battle shaped up. The HOA board's argument was basically, look, state law says we can create fees and our own documents say we can amend the bylaws. As long as our new rule doesn't directly contradict the declaration, we're good to go. But Mr. Heekin's argument was much more direct. He said, you can't use a simple bylaw to do something the Constitution forbids. This was just a sneaky way to get around a vote you lost, and that's a breach of good faith. So that's the big question for the judge. Did the board find a clever, totally legal loophole to get the money the community needed? Or was this a flat-out illegal power grab, just totally defying the homeowners they were supposed to represent? All right, so the case goes to the judge. And you know what? The entire decision came right back to that simple hierarchy we talked about at the beginning. The Constitution is king. It all came down to this one little sentence, tucked away in Section 5.6 of their very own declaration. It says as clear as day that regular assessments, the money collected to pay for common expenses, shall be uniform for every single owner. See, the board tried to be clever by calling their new 1% fee a special assessment. but the judge looked right past the name and asked, what's the money actually for? It was for upkeep, operations, capital improvements. The board's own letters even said the fee was to avoid raising annual dues for everyone. The judge concluded, yeah, that's for common expenses. That falls under regular assessments.
And that, right there, leads to the killer question, the one there's really no good answer to. If the fee is for common expenses that are supposed to be uniform, is a fee that's only charged to people when they sell their homes based on wildly different sale prices. Is that uniform?
And the judge's answer was an absolute resounding no. Of course it's not uniform. It forces just a few members, the ones selling their homes, to pay for costs that the community's own constitution says have to be shared equally by all members. And because of that, the new bylaw was in direct conflict with the declaration, which makes it totally invalid.
This is the big lesson here, the thing you gotta remember. In any HOA, there is a crystal clear hierarchy of power. The declaration is the Constitution. It always wins. Any other rule, any bylaw, any board decision that goes against it is automatically void. End of story. So, in the end, the judge sided completely with the homeowner. Boom. Both of the board's sneaky bylaws, the 1% fee and the architectural rule, were thrown out. Thomas Heekin won, and the HOA even had to pay him back for his court filing fee.
You know, this whole story from one small community in Arizona holds a really powerful lesson for millions of us. Your HOA's declaration is your community's most important document. It's what protects your rights as a homeowner. Which really just leaves us with one final thought. You have one of these constitutions, too. Do you have any idea what it says?